Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the case of the Queen and Rana. This is a provincial court decision out of Ontario. It just came out. So at this point, it's not going to be clear how much impact this case will have. I'm hoping not a whole lot because in my view, the judge makes several errors in it, and it would be very unfortunate if those errors were to be picked up by future courts. So let's have a look at this case. It's also a really good case in terms of sort of examining the interaction that Mr. Rana has with the police, because Mr. Rana makes some mistakes, and also the police could have handled things way differently. I'm going to warn, however, this is a bit of a long video, and some people have said, when you do these long videos, can you give me like a short attention span version at the start, because I don't have the patience to watch through all of that. So the short attention span version is Mr. Rana calls the police. He's looking for help removing a trespasser from his property. He wants this person out of his house because they're having a fight. The police aren't showing up at the speed Mr. Rana would like, so he makes further phone calls in which he intimates that he, has a firearm and might use it in self-defense. The police show up and eventually remove the trespasser, but they also charge Mr. Rana with storage-related offenses, and, so he probably isn't terribly thrilled with the outcome because they also seized his firearm. And if you are, one of these people with such a short attention span that you don't really want to learn about the case, here are some jingly keys to entertain you. All right, for everyone else who actually wants to sort of figure out what's going on with this and see the legal analysis, let's dive in. Again, sorry it's going to be a bit of a long one. And I'll also try to leave a sort of timestamp if you want to jump to what I think the most interesting and important issues on this one are. So again, Queen and Rana. And I'm cutting out a whole bunch of this because Mr. Rana is a self-represented litigant. He makes some arguments that I don't know would have been made by counsel representing him. I can't really judge because I wasn't there at the trial, but that's sort of my interpretation here. They don't go very far, these other arguments, and so I don't want to go through those in a whole lot of detail. I'm trying to cut things down as much as I can. So Tariq Rana, Mr. Rana, was tried for the offenses of careless storage of a firearm, namely a handgun, contrary to Section 86 sub 1 of the Criminal Code, and contravening a regulation made under Section 117H of the Firearms Act. So this is a violation of the storage regulations in relation to storage of firearms and restricted weapons, contrary to Section 86 sub 2 of the Criminal Code. So 2 counts, and this is very common. They'll charge the careless storage and they'll charge the storage contrary to regulations because they can convict you on either of those and still get a penalty. Crown elected to proceed by summary conviction on both counts, so he's not looking at quite as high a jail sentence or, punishment as otherwise. And Mr. Rana pled not guilty to both offenses and represented himself at trial. I'm going to have some comments here on his decision to self-represent at trial because there are some places where, notwithstanding the fact that the judge really talks up his representation of himself, where I think he may have kind of tanked himself in so doing. So let's have a look at this. So these are my reasons on Mr. Rana's application seeking remedies for alleged violations under the Charter of Rights and Freedoms, as well as the issue of whether the Crown has proven the offenses beyond a reasonable doubt. The reasons are lengthy and will proceed in 5 parts. Again, apologies about the length. First, I will provide an overview of the trial proceedings, which will take some space in the reasons, but it is important context for Mr. Rana's charter arguments. So some of these arguments I'm going to, again, cut out, but the judge goes through them in some detail. I'm going to try to link to this decision. I'm not sure if it's available on Canly, so I'll have to find that out later. So he's going to go through a number of things, outlining the legal issues in the analytical order, address his charter arguments and whether any evidence should be excluded, and address the merits of the prosecution with the admissible evidence, including whether the Crown has met the burden of proving the offenses. So that's going to be sort of the key thing here, but I also want to go through some of his charter arguments here. So they note that depending on how the issues are resolved, I may not have to decide other issues as they may be moot. For example, if I determine Mr. Rana's charter argument succeeds in excluding the evidence of the firearm, it will gut the Crown's case. This is very common when we're dealing with exclusion of evidence issues. The Crown's charges here are careless storage of a firearm and storage of a firearm contrary to regulations. So if the court says, listen, you can proceed on these charges, but we are excluding the evidence of the firearm, what's left of the Crown's case? This also happens with, for instance, drug charges. Somebody's found with, however much of whatever drug. And, if the court says, listen, you searched improperly, you shouldn't, have done so, we're excluding the drugs from the trial, the Crown at that point might be in a position of having to prove like possession of the drug for the purpose of trafficking, but they can't mention the drugs. So those charges just go away. That's what the judge is meaning here, is basically if he excludes the firearm from consideration, the charges are at that point gone. The Crown's going to have no choice but to lose. So the charges. The circumstances of Mr. Rana being charged with the above criminal offenses and the protracted litigation that followed are somewhat unusual. This is a bit of an understatement. On October 15th, 2018, Mr. Rana placed 3 911 calls to the Durham Regional Police Service, which they will now abbreviate as DRPS. I'll probably just say the police, to report that an unwanted male was in his home and refusing to leave. The trespasser was a disgruntled person known to Mr. Rana and his family. Mr. Rana told the 911 dispatchers he was a registered firearm owner and gets very violent and might kill him in self-defense, but later clarified he wouldn't use his firearm. Let's just stop here and say, do we think that was a good thing to tell the dispatcher? Was that a smart move by Mr. Rana? No, it was not. Carrying on. He asked for the police to attend at his residence, ostensibly to remove the trespasser. Eventually, the police arrived and safely removed the trespasser, who did not have a firearm. While inside the residence, and without a search warrant, the police investigated the circumstances of the firearm by asking Mr. Rana about its whereabouts. Ultimately, Mr. Rana, along with his spouse, Mrs. Rama, turned over a 9mm Beretta handgun, which was in a gun box. The firearm didn't have a trigger lock, and the gun box was not locked. Mr. Rana was legally registered to possess and store the handgun, but the Crown says the handgun was being carelessly stored given the manner in which it was discovered. Mr. Rana was charged accordingly. All right, so that's a broad overview. We're going to get more facts than that because we're going to need more facts than that. But this is sort of a brief summary. Overview of the charter arguments. Mr. Rana's position is that the police violated his rights under the charter in several ways, and this alleged impropriety spilled into the courtroom during the prosecution. So he's also making charter arguments specifically against the Crown themselves. He says the conduct of both the police and the Crown Attorney's Office, and in some cases the conduct of the prosecuting Crown, Mr. Black, amounts to an abuse of process and law, and the court should cure this injustice by staying the proceedings. Now, sometimes that's an argument you got to make, but this is an argument you want to make sure you got really well lined up, because this is always going to be a tough sell. I'm not going to cover most of those arguments because, in my view, he falls well short of where he needs to be on that one. Alternatively, Mr. Rana says that the police violated his charter rights and the evidence of the firearm should be excluded. In any event, he argues, he's not guilty of either criminal offense because the handgun was safely stored in a designated gun box, which was stored in his wife's jewelry safe, and therefore its storage was not careless as it was in compliance with the storage regulations under the Firearms Act. Mr. Rana's charter argument complaints are grounded in alleged violations of Section 7, 8, and 9 of the Charter. The Sections 8 and 9 allegations involve an argument that the police entered and searched his home without a warrant and without reasonable grounds. Mr. Rana says he was arbitrarily detained in his residence in violation of Section 9 of the Charter when the police began to question him about the whereabouts of the firearm and coerced him into searching for the firearm. He says there were no grounds for the police to conduct a safety search because they were called to remove a trespasser, and their authority vanished shortly upon entry into his home. In addition, Mr. Rana alleges a separate violation of Section 8 of the Charter on the basis that the police failed to file a report to justice in respect of the seized firearm, which led to it being unlawfully detained in police custody as it remained in their possession without judicial supervision. He says this problem was aggravated when the police secured its continued detention with a new report during the trial based on trial testimony. As a remedy for these alleged violations, Mr. Rana seeks to exclude the evidence of the firearm under Section 24.2 of the Charter. So he wants the gun not considered by the court. The Crown concedes there was a warrantless search and arrest, which is a prima facie violation. So prima facie, again, means sort of before anything else is considered, but not determinative. It means that, unless there's some other evidence, it's a violation, but other evidence may say that it's not a violation. So prima facie violation of Section 8, but defended the actions of the police based on their common law powers to investigate emergency 911 calls. The Crown says this duty includes the authority to enter a residence and authorizes a search related to this purpose, including a broader purpose of protecting the safety of the public. The Crown says Mr. Rana was not detained when he was asked about the firearm because the police were not investigating him, but rather responding to the 911 call. Further, the search was reasonably conducted with Mr. Rana and his spouse offering to assist with the search. The firearm was seized in plain view once the police had reasonable grounds to believe it was being stored carelessly. The Crown says the Section 8 and 9 complaints regarding the search should be dismissed or alternatively were not serious police conduct which attract a charter remedy under Section 24(2). With respect to the Section 8 complaint involving the report issue, the Crown concedes the police failed to file a timely report as required by the Criminal Code, which resulted in a Section 8 charter violation. So they're agreeing that his rights were violated by failing to file that report. But the Crown defends this complaint by arguing that this was a technical violation motivated by good faith, and in any event, it was corrected during the trial when a new report was filed. During the trial seems a little late to me, but anyway. The Crown says the charter violation flowing from the report issue was not serious and should not result in a charter remedy under Section 24(2). He also makes a Section 7 complaint about the fact that they filed a separate information, that they filed a supplementary report. Ultimately, this doesn't seem to go anywhere, and I'm going to skip it, which you might be thankful for, because this is, again, going to be a long video. So, chronology of the legal proceedings. Mr. Rana chose to represent himself at trial. It was his constitutional right to do so. Mr. Rana conducted his defense ably because it is obvious he is well-educated, resourceful, and respectful. Now, I underline this in my little block here because remember this bit. The court is making observations of his knowledge, of his behavior, and so forth. Do you think those might come back to bite him? I think they do. Let's have a look at that. Remember this. Remember that the court considered sort of his demeanor and his ability to present arguments when we get to another point down the road. So I'm just putting a flag on this one. Even though he advanced charter complaints impugning the integrity of the police and the Crown Attorney's Office, including Mr. Black, he did so professionally. And this takes him well above the average self-rep who, if they were making those complaints, would probably... They usually come off as sort of petty and spiteful and angry and bitter, and it really doesn't endear them to the courts. So... Now, I don't know if the court is actually meaning this because, and I mean, I presume they do, but the court will often talk up self-reps and sort of big them up, notwithstanding the fact that they may not have done a great job. And I don't know if Mr. Rana did or did not do a great job. The court certainly says he did here, but I don't know how much of that is sort of assuaging feelings here. While it remains to be seen whether any of these legal arguments have any merit, he advanced the arguments while conducting himself civilly and with some forethought, which is expected of litigants appearing before the courts. So they're patting him on the head. You did a good job by not screwing up. Okay. A criminal trial is not a mediation where the parties are expected to come to an agreement about disputed issues. Criminal cases are adversarial in nature. This case was no different. Criminal trials with self-represented litigants are challenging for courts, and this case was no different. Courts have a duty to ensure a litigant receives a fair, but not necessarily a perfect trial. This includes a duty to provide reasonable assistance to a self-represented litigant. This duty was realized in this case with the assistance of Crown Counsel, Mr. Black, who, as these reasons will demonstrate, also acted professionally by providing diligent assistance to both Mr. Rana and the court. So the Crown Prosecutor actually had to step in and help Mr. Rana here. This is not terribly uncommon. And, where you have self-represented individuals. But so what you'll see sometimes is a self-represented individual who's trying to tender some evidence, and the Crown might have to say, well, here are the here are the issues you need to get out in order for that evidence to become admissible. Did you want to try again? That kind of thing. But do you ever really want to be in a position where the person who's trying to convict you is also the one you're relying on for help? I don't think so. So carrying on. Despite some of the charter complaints leveled at his office and him personally, he reacted civilly. He assisted the court in making witnesses available for Mr. Rana to be called and responded with focused legal submissions in response to Mr. Rana's arguments. So he didn't make Mr. Rana subpoena these people, he just brought them in. This is, again, the kind of conduct we expect from diligent and honorable Crown. Crown are required to sort of uphold the honor of the Crown. And it sounds like Mr. Black here was doing his job admirably. So I got no complaints with what I see here from Mr. Black at all. So it is not lost on the court that Mr. Rana defended himself against the backdrop of feeling victimized by the administration of justice. As he repeatedly reminded the court, he called 911 for police assistance to remove a trespasser and ended up being charged with criminal offenses. Yeah, no kidding, he's upset. He says the police embarrassed him in front of the trespasser and his family. In his final written submission to the court, he wrote, "The Crown has lost its way in prosecuting the Queen and Rana." I'll let you leave it in the comments below as to whether you think the Crown has lost its way in prosecuting the Queen and Rana. I don't fault Mr. Black for bringing these, charges because there are some substantial disputes as to the facts. So that's something to keep in mind when you're sort of judging Mr. Black here, is that Mr. Black has different facts because he will have had the police statements, and they wouldn't have Mr. Rana or Mrs. Rana's testimony at the point where they're deciding to proceed with charges. So as the trier of fact, my function is to judge the evidence to determine if it proves his guilt to the requisite legal standard. I must do so dispassionately. Viewed in this context, the trial proceedings could have, but did not devolve into a mudslinging contest. Both parties should be commended for acting civilly and professionally. Again, this is the judge patting Mr. Rana mostly on the head for not being a giant jerk. And unfortunately, this is kind of a big deal when you're dealing with self-reps, because a lot of self-represented accused come in, they can't keep their emotions separate. It's really hard to remain dispassionate. And I say this as a person who has actually gone in and self-represented in a matter. Even as a lawyer where you have developed the skill of sort of disconnecting yourself, it's a lot harder when you're a self-represented individual. If you haven't developed that skill, a lot of this comes down and feels a lot more personal. Especially, we can see moments when he starts cross-examining the witnesses, and the witnesses give answers like, "You did this." It's really hard for people to keep their cool, so the court is giving Mr. Rana props for having done so. But this really illustrates sort of how perilous self-representation can be. The witnesses. Crown called 2 911 operators who received the frantic phone calls of Mr. Rana and police witnesses involved in the search and seizure of the firearm from his residence. And they named the police officers. Mr. Rana elected to testify in his defense and also called his spouse, Mrs. Rana, who testified with the assistance of an Urdu/Punjabi interpreter. Additionally, the Crown made some police witnesses available for Mr. Rana, including some additional police officers. Mr. Rana agreed to blend all the evidence on the trial and charter issues. This is a very common thing. You can technically have separate rounds where you call evidence on the voir dire for the charter issues. And then if that evidence goes in, then you have a separate trial where you have to call all the evidence again. But blending the evidence is really common because it makes things a lot easier, because you just agree that if the evidence goes in, that you just say, that evidence we already heard, we can now use that stuff we heard. We don't have to call it again, which, again, can save you days of trial. So finally, in support of his mid-trial charter applications, which I will review below, Mr. Rana filed a lengthy affidavit appending some of his disclosure materials. This too becomes part of the record, although given its timing, the Crown did not have the opportunity to test this evidence through cross-examination. Again, what we're seeing here is a little bit of sort of procedural irregularity that comes up when you have self-represented individuals. So the admissions. Some things were conceded by each party. Mr. Rana conceded the admissibility of the 3 911 calls, which were made Exhibits 1. Makes sense. I don't see how we'd be able to keep that out. In addition, the parties agreed to admit certain facts pursuant to Section 655 of the Criminal Code, so these are agreed admissions. First, the seized firearm was a restricted firearm within the meaning of Section 2 of the Criminal Code, as it was tested by the Center for Forensic Sciences. The parties had secured this admission at the proceedings on January 28, 2019, and prior to commencing trial, he confirmed this admission on the record. Second, they admitted 17 photographs of the firearm as a scenes of the crime officer. I'm going to skip over the rest of the admissions because they relate to things I don't really want to talk about on this one. So on January 8th, 2020, Mr. Black closed his case subject to any reply evidence on the blended voir dire. Mr. Rana testified in his defense and was cross-examined by Mr. Black. Mr. Rana called Mrs. Rana, who testified with the assistance of an Urdu interpreter. She completed her evidence in chief, but was not cross-examined. And they also note, Mr. Rana ably and dutifully followed the court's direction by filing the applications in writing and with proper notice to the Crown. Again, this is kind of patting Mr. Rana on the head for the sorts of things we would expect counsel to do without comment. I mean, a judge would never, on precisely none of my trials has a judge ever said, we really appreciate that Mr. Runkle filed his applications in writing as the law requires and gave proper notice. It's just assumed. So again, you can see that self-represented individuals have low standards applied to them, which tells you something about the results they typically get. I will note that Mr. Rana appears to have defended this way more ably than the average self-rep, but there are still some issues that come up in terms of this. So even though he did a way better job than most people could be expected to, he still might have preferred to have a lawyer. And if he appeals this one, or if he has appealed, I think the appeal deadline, if he hasn't filed, may have run out. But I really hope he's getting a lawyer on that one. There are some excellent lawyers in Ontario. Mr. Burlew, Solomon Friedman, Fatty Mansour. There's good lawyers in Ontario for firearm issues. And none of them are paying me for the shout out. So if you're worried about that. All right, so while the permutations of blended hearings may be difficult for some self-represented litigants, Mr. Rana is an exceptional self-represented litigant. I repeat, he proved to be an able advocate for himself. His oral submissions and legal materials are objective proof of his exceptional abilities. Again, do you see a way that this could actually come back to bite him? We'll see. So, with the above backdrop in mind, these reasons will address the following legal issues. The first one I'm going to ignore entirely because it's the information issue, and if you want to read about that, pull up the case and read about it, but I don't find it terribly interesting. Was there a Section 8 charter violation on the basis of the police entering and searching Mr. Rana's residence without a search warrant and by failing to file a police report and/or filing a report during the trial proceedings? So that one's a more interesting one because he's trying to exclude the evidence. Did the police form lawful, reasonable, and probable grounds to arrest Mr. Rana? I'm going to skip over mostly. Was he arbitrarily detained by the police in his home under Section 9 of the Charter? That one I think is a little more interesting, so we'll look at that a little more. If there are proven Charter violations, has he met his onus to exclude the evidence of the firearm under Section 24(2)? We're going to cover that one real briefly. And if the evidence of the firearm is admissible, has the Crown proven beyond a reasonable doubt that he carelessly stored his firearm contrary to Section 86(1) of the Criminal Code? Combined with, have they proved that he contravened a regulation in respect of storage of a firearm under Section 86(2) of the Criminal Code? So those two, I think, are going to be real interesting. So we'll have a look at things here. Again, this is going to be a long video, so yeah, my apologies. Court continues, before I turn to the charter issues, I will summarize the evidence of the witnesses. It is common ground that Mr. Rana placed 3 911 calls, which I will itemize below. While there is no conflict that the police entered his residence, there is a credibility dispute about what happened in his residence, including the circumstances of the search that led to the discovery of the firearm. In summary, the defense position is that the firearm was stored in a locked jewelry safe and removed by Mrs. Rana after Mr. Rana called 911 and illegally seized after the police demanded its whereabouts. after the trespass call had dissipated. The Crown's position is that the police lawfully responded to the 911 emergency call, and there was no locked safe. Instead, the firearm was unsafely stored in a gun box in a bedroom closet and lawfully turned over to the police. I will commence with a summary of Mr. Rana's evidence. So when I said before that because there's some substantial disputes as to the facts, we can't really judge Mr. Black too harshly or really harshly at all for deciding to proceed with this. This is a big one. Mr. Rana says there's a locked safe. The police's view and the Crown's view, when they're sort of looking at what they have, is that there was no safe, that Mr. Rana's making that up, that he's lying about it. And that's a big deal in terms of a storage issue as to whether or not there is or is not a safe. So continuing on. Evidence of the 911 calls. On October 15th, 2018, Mr. Rana called 911 to have a trespasser removed from his home. The 911 calls were played in the courtroom and made Exhibit 1 on the blended voir dire and trial proceedings. To provide some context to the calls, Mr. Rana testified a family acquaintance, Mr. Rehan Qureshi, attended at his house uninvited and was let in by Mr. Rana's teenage daughter. Mr. Qureshi proceeded to blame Mr. Rana for instigating his, Mr. Qureshi's daughter's divorce. Mr. Rana explained he had previously testified in court proceedings, which ultimately led to some dissension in the Qureshi household. Mr. Rana asked Mr. Qureshi to leave, and he refused. Mr. Qureshi began to raise his voice and threatened him. Mr. Rana testified he never threatened him in response, but became scared as his children were in the house. As a result, he decided to call 911 to have the police remove Mr. Qureshi as a trespasser. So this guy was, let into the house, but he clearly came with a grudge, is Mr. Rana's evidence, and it doesn't appear that there's any sort of contradictory evidence on that point. So guy comes to the house, he has a grudge, he's upset, and he's starting to scare Mr. Rana. So Mr. Rana then calls 911 and says, I need help. And we can see how this goes. So the first 911 call was made at approximately 6:31 p.m. Mark that time, 6:31 p.m., with Mr. Rana speaking with the dispatcher, Ms. Alana Timmers. She testified Mr. Rana told her about Mr. Qureshi as the father of his wife's best friend. He reported that Mr. Qureshi is threatening his 16-year-old daughter with violence. The other salient aspects of the first 911 call include the following comments made by Mr. Rana. Please have an officer here immediately, and to remove a trespasser, Mr. Qureshi is sort of that looks like an editorial comment, so it just looks like it's, please have an officer here immediately. I don't want to go down because I might kill him. I get very violent and I can take care of him, and I don't want to do that. I haven't even spoken to him face-to-face. It's just my wife who mentioned that he's in the house. I haven't even spoken to him face-to-face. Just my wife told me he's in the house. He's known to use alcohol and drugs. So some of these comments were not a great idea. Telling the dispatcher, hey, I might kill him and I get very violent. These are not great comments to make to a 911 dispatcher. Keep in mind, everything you say to that 911 dispatcher is being recorded. It's like you're telling it to the cop. It's like you're telling it to the CFO. It's like, all of these people. So saying, I get very violent is a really dumb thing to put on a 911 call because the chief firearms officer, even if he was acquitted on all of this, the chief firearms officer could listen to that recording and go, is this really what we want from gun owners? I don't know. So, yeah, that was not Mr. Rana's best move. So, continuing on, Mr. Rana testified he was expecting the police would arrive immediately after the first 911 call, but they did not. I'm not sure why he would expect the police would arrive immediately after the first 911 call. Most people who have any familiarity with 911 response times would not expect that at all. So as a result, he called 911 again at 6:44 p.m. So we're talking about 13 minutes have passed, and told the 911 dispatcher, Miss Pauline McKnight, that he previously called 911 and nobody responded to the call. The following are salient aspects of what Mr. Rana said on this call. I already called 911 and there's no police here. I need them as soon as possible. I have a weapon and I will use it on him. Again, we're not talking about the smartest comments to make to the 911 dispatcher. I do have a weapon. I have a lawfully obtained weapon. I'm not going to use any weapon. It's a registered 9mm handgun. I have a firearms license for that. He's here to threaten me. Yeah, I don't know why some of these comments would be made. We don't have a full recording in the description here, but, you know, I have a weapon and I will use it on him is not a great comment to make here. Now, of course, you're going to be under adrenaline stress and so forth, but yeah. According to Miss McKnight, Mr. Rana appeared animated and agitated with a clear undertone of anger in his voice. Based on the above information, she changed the priority of the call from an unwanted party to a person with a weapon. Notice, unwarranted party to a person with a weapon. When we think, who's the unwanted party and who's the person with a weapon, this dispatcher just flicked the police's attention from the guy he called the police on to him. This is an important moment in Mr. Rana's life because this is probably a big part of when things start to go way wrong for him. This information was reflected in the police call card, which would have been available to any police officer that was dispatched to the call. In cross-examination, she confirmed the call card would also have reflected Mr. Rana's status as a certified firearm registered owner, or CFRO, and his comment he wouldn't use his weapon. The third 911 call commenced with a dropped call, followed with Mr. Rana advising the dispatcher in an excited state, "I have a weapon and I need to defend my family. Hurry up." Mr. Rana repeats the complaint of the trespasser and is clearly anxious and upset, repeating, "Just hurry up." I don't know the timeline on that one. It's not provided here. We don't, it's not clear how late that was, but if it was another 13 minutes in, that wouldn't surprise me a whole lot. The usual complaint about 911 is that, when seconds matter, the police are minutes away. Here, it's really lucky that the trespasser wasn't engaging in violence, because if he had been, he would have had lots of time. So there might have been a reasonable reason to go and get the weapon, but telling the dispatcher, "Hey, I'm going to kill this guy." No. Bad. This is a bad idea. So, but you can see what seems to be happening here is that Mr. Rana is calling the police, and it appears that he's kind of, he makes his first phone call, and then when that gets no response, he sort of calls and makes follow-up calls that are getting ever more kind of pointed. It's like the old joke about, there's two guys breaking into my shed. "Oh, sorry, we don't have any cars." And then calling back, "Oh, don't worry about it. I just shot them." "Oh, we'll send everybody." "I thought you said you shot them." "No, I thought you said you didn't have anybody." Like that old joke, which I've mangled here and probably ruined for you if you haven't heard it. But, it's a really bad idea to sort of talk up the dangerousness of the situation to get the police to hurry up. But at the same time, the police here have got to be hearing that there's a trespasser who is causing people fear, and it takes a while for them to get there, because we see Constable Birmingham testified he was dispatched to Mr. Rana's residence shortly before 7 p.m. That's the time he's dispatched. So first call is made once again. So that was 6:31 p.m. It takes half an hour for this particular officer to get told to go there. If Mr. Rana was in a life or death situation, do you think half an hour is enough time to get murdered? I think half an hour is more than enough time to get murdered. So this is concerning to me. While in transit, he learned about the 911 calls involving a male trespasser and information that the caller, Mr. Rana, had a 9mm handgun and would defend himself. Upon arriving at the residence, he saw Mr. Rana at the front porch standing by himself. After speaking with him quickly, he determined Mr. Rana was not in possession of any weapon. So Mr. Rana does not have the gun on him, which is smart. He testified, given the nature of the information on the 911 call involving a 9mm handgun, the police entered Mr. Rana's residence to ensure the safety of anyone who may be inside. Upon entering, he saw a male sitting on the couch, later identified as Mr. Qureshi. He spoke to him briefly. He also confirmed the presence of Mrs. Rana, who was inside the house. He confirmed there was nobody in the home with a firearm who needed medical attention. He said the scene was chaotic as everybody appeared agitated. It was apparent there was a heated argument in a language that was not English, which he could not understand. After speaking with Mr. Qureshi, he learned that there was some sort of dispute between him and Mr. Rana's family. So again, at this stage, things seem, you've got a guy who's not invited and they're all upset. And so what does the officer do? He turned his attention to the 9mm handgun referenced in the 911 calls. He attended upstairs after Sergeant Clausen had gone upstairs with Mrs. Rana. When he arrived upstairs, he saw Sergeant Clausen with a box. While he did not search the premises, he learned from Sergeant Clausen that the box contained a handgun that was retrieved from a closet in a bedroom, which in his view did not appear to be a room where one might store a firearm. He ensured the firearm was proven safe, which means it was not loaded with ammunition. He testified there was no trigger lock on the firearm, nor was the gun box able to be secured with a lock. In cross-examination, the officer confirmed his authority to enter Mr. Rana's residence and search for the firearm was vested in his common law powers. In other words, he did not say he relied on any statutory authority. He explained he did not have to knock on Mr. Rana's door as Mr. Rana was standing outside of the residence on the porch and was invited inside. Further, he added that upon entering the residence and confirming that nobody was in any immediate danger of a firearm, he still felt prudent to ask about the firearm as it was the basis of the 911 call. Remember this part here. Nobody was in immediate danger of a firearm. Putting a flag on that, remember that we just mentioned that. He still felt prudent to ask about the firearm as it was the basis for the 911 call. He stated, "My purpose for being there was not to take away your gun, per se." You can see this is the kind of language that gets used with self-represented people cross-examining. He's talking about your gun. And my purpose for being there was to ensure the safety of everyone, including your own, because you called us. Your safety. It's really hard to, for somebody, again, to sort of keep their cool when the officer is addressing them personally and making it personal about them. Whereas if the lawyer was asking the questions, he would have said, my purpose for being there was to ensure the safety of everyone, including Mr. Rana, which is less personal for the lawyer. So finally, the officer also testified he wasn't involved in the search of the firearm from the bedroom, and it was never in his plain view until after it was shown to him by Sergeant Clausen. So he's not the guy who found the gun. Evidence of Acting Sergeant Robert Clausen. He's been employed as a police officer for approximately 11 years. On the date in question, he was on duty as an acting sergeant in a supervising capacity. He was working alone and responded to a radio call for an unwanted person at Mr. Rana's residence. He was operating a fully marked cruiser. He learned from dispatch that the caller had a 9mm handgun and, if necessary, would use the firearm to defend himself. There was also information that the caller said he can act violently. At 7:07 p.m., he arrived at Mr. Rana's residence, and the other officers were already on scene. So again, half an hour kind of response time. Mr. Rana was standing outside the residence and learned he was the 911 caller. He spoke to Mr. Rana about the 9mm firearm and testified Mr. Rana told him the firearm was located upstairs in a box. The sergeant determined that there were exigent circumstances in locating the firearm, given the nature of the 911 call, including the reference that it may be used in self-defense. As such, he decided to enter the Rana residence without seeking a search warrant and search for the firearm. Upon entering, he observed a male and female inside the residence. Mr. Rana escorted him upstairs into a bedroom which was already opened. Mr. Rana proceeded to look for the firearm in the bedroom and on a shelf, but he could not find it. At this point, Mrs. Rana entered the bedroom and went to the walk-in closet and began rifling through the laundry and presented him with a blue box which was buried underneath some clothing, not a locked cabinet. The blue box had a Beretta USA symbol inscribed on it, which he understood to be a firearm. Exhibit 3 are the photographs of the firearm and box identified and these are just exhibit number or just numbers for reference. He observed that the box was not locked. He opened it and saw a 9mm pistol with a magazine seated in the receiver. He removed the receiver. There were no rounds in the magazine, nor was there a trigger lock. I suspect that he didn't remove the receiver. I suspect he was just, proving this safe, but the language often gets very sloppy around firearms in criminal cases. Sergeant Clausen testified that he did not obtain a search warrant for the Rana residence as the 911 calls made it clear that the caller had a 9mm handgun, and it was urgent that we locate this firearm forthwith. Was it? Why? That's going to be a question that we have to consider here. In cross-examination, Sergeant Clausen confirmed he's not designated as an inspector under the Firearms Act, which permits entry into a home, but instead entered the home under his common law powers to investigate a possible criminal offense of threatening somebody with a firearm, which he learned from the 911 call. Again, that's not really what they were, that's not what they were called for, but Mr. Rana's follow-up calls kind of moved it to that category. Also, the inspector under the Firearms Act is kind of going into the weeds here, because this isn't a Firearms Act inspection at all. So this looks like Mr. Rana was possibly chasing the wrong issue, and that happens. He said upon entering Mr. Rana's residence, he didn't know if anybody had a firearm and did not search Mr. Qureshi nor Mr. Rana or his spouse. When asked if he still believed the circumstances were exigent in his mind after entering, he stated, "Absolutely. I don't know who had access to the firearm." He confirmed while inside the residence, he did not know if the constable had a conversation with Mr. Rana about the firearm. Now let's think about this. So he's saying that there's exigent circumstances because there's a gun and we don't know where it is. Wouldn't the first thing you'd want to do would be pat down the people? Because if I'm an officer entering onto a scene, or, just a person, and, I'm worried about getting shot from this gun that's somewhere, my main concern is if that gun is on a person. If somebody has that gun, who can, pull it out and pull a trigger. I'd want to start out by searching and checking those people. Because if it's in a box, what's it gonna do? It's not it's an old sort of joke about, guns don't shoot people, people shoot people. Well, it's not, if it's in a box somewhere, it's unlikely to load itself, point itself at a person and fire. So I'm kind of wondering here, and this seems like maybe experienced counsel could have sort of dove into this issue and said, like, how are you saying this is exigent circumstances if you're not checking the people? Like, aren't the people the danger? Anyway, Sergeant Clausen was challenged by Mr. Rana about whether Mrs. Rana handed over the gun box to him directly or whether she gave it to Mr. Rana, who handed it over to the police. Ultimately, the officer conceded he couldn't recall for sure how the box ended up in his hands, but he was clear that it was retrieved by Mrs. Rana from a walk-in closet. He was also adamant that he never entered the walk-in closet and instead stood at the threshold of the closet. When asked why he didn't enter the closet, he responded, "Given the size of the closet and the fact that there's a potential of a firearm being in there for my safety, I'm not going to stand beside you in a small confined space like that." When challenged on his grounds for the search, Sergeant Clausen said, "I did not know where your firearm was at the time, and I believed you had a firearm. You had a firearm registered to your residence, as well as you made reference to the call taker at 911 that you had a firearm, and you would use it." This also seems weird to me, because for officer safety, you're worried about this gun and exigent circumstances and this danger that is going on. Why would you send someone else to get the gun, who you don't trust to be in the small confined space? Because I would be worried, that this person would retrieve the gun and that gun might be loaded and turn around and put a hole in parts of me that should not have holes. I have a certain number of, openings. I don't need any others added to me by somebody with a firearm. So to my mind, this is something else that, as counsel, I would have been riding this particular issue. You're afraid, you're worried about this gun, you're concerned that somebody might take this gun, might use it violently, and you're letting them pick it up? Really? No. Like, normally when I've seen this happen, what they'd want is two officers, one officer to watch the person and the other officer to go and find the firearm. And they might take direction from the person. But, this notion of this person who we just met, they're going to pick up the gun. This tells me that maybe these concerns weren't as serious as they were. However, we're going to be stuck with the judge's findings of fact. These are just sort of things I look at as a lawyer when I look at these kinds of cases and sort of wonder how I would have done it. Is this something that I could have maybe got better evidence out on? And I don't know, like, this is counterfactual armchair quarterbacking after the fact, but this seems to me like, this is the kind of thing that just makes you go, was there something there that you could have dug into? And that kind of, digging into is really the fun of litigation. So, frustrating when you see this kind of thing where you just kind of think that somebody almost sort of touched the mark, if that makes sense. So, evidence of Constable Pallister. He was called in chief by Mr. Rana. He has been a police officer with the DRPS for over 25 years. On the date in question, he too was dispatched to Mr. Rana's residence and arrived within seconds of Birmingham and Clawson, which doesn't seem to be what Clawson said, but regardless, this is not a huge deal. They're all kind of arriving at the same time. He testified he parked his cruiser a few homes away and walked to Mr. Rana's residence, which is depicted in photographs marked as Exhibit 4. Upon arriving at the residence, he saw Mr. Rana standing outside and spoke to him about the circumstances of the firearm, which, according to him, Mr. Rana downplayed. In his view, Mr. Rana was not being deceptive, but was also not forthcoming about the firearm. Gee, why would he not have been forthcoming? You guys are so nice to him here. Okay, yeah. While he couldn't recall the exact conversation, Mr. Rana was focused on the intruder in his home and wasn't volunteering information about the firearm, which raised his suspicion. He's not required to volunteer anything. So, 7:09, he advised dispatch over radio that the matter had been overblown. And yeah, Mr. Rana seems to have overblown the matter, which doesn't work out to him all that well. Do you think maybe the officers might be a little ticked at Mr. Rana for, dragging them there in a real big hurry? Yeah, I mean, there's 3 cops there. This has cost a whole pile of money. He testified he did this because he suspected other officers, including the K9 unit, would also be dispatched to the home, possibly in haste given the information about the firearm, and wanted them to slow down. Basically, he's like, everybody's been called out that this is a big deal. It's not a big deal. This is a giant waste of our time. Let's try to unravel that. But do you think that a giant waste of their time is something that they might affect how they go about things? Yep. In the end, he said other police officers did not have to attend, except for Sergeant Story, which is routine when there's a call of a firearm. Sergeant Story was made available for Mr. Rana to call, but never ended up testifying. Constable Pallister said Sergeant Story arrived and spoke with other officers on scene. He briefed Sergeant Story on why Mr. Qureshi was present in Mr. Rana's home, and after doing so, Sergeant Story left without entering the home because the situation had calmed down. So again, don't really know what happened, but this other officer arrived and was basically sent home because it's not as big a deal as they thought it was. So he entered the home at the same time with Birmingham and Clawson. He was likely the first person to enter. Upon entry, he saw a person sitting on a couch in the living room. He spoke with Mr. Qureshi and did a pat-down search and a quick search of the couch. He was searching for a firearm, but didn't find anything of interest. Unlike Mr. Rana, Mr. Qureshi was forthright and said he had no gun. Okay. He didn't search anybody else for a firearm. Again, you're so worried about these exigent circumstances. Wouldn't they be the first people you'd search? He testified that based on the call card, he believed the firearm was either on Mr. Rana or Mr. Qureshi. Mr. Qureshi told him he was in the home because Mr. Rana was speaking to his daughter, which he did not like. Pallister added, while he knew other officers were searching for the firearm, he was not involved in the search. Constable Birmingham remained on the main level, but he was unsure about the whereabouts of Clawson. Eventually, he saw Acting Sergeant Clawson holding the firearm, but did not speak to him about its discovery. In cross-examination, he said the police did not apply for a search warrant, as other officers were dealing with the matter. In cross-examination by the Crown, he confirmed that he was not involved in the search for the firearm. He said he remained in the home until he saw Sergeant Clawson bring the firearm downstairs, and after determining it was safe to leave, left. He confirmed that the exigency of the police investigation dissipated after the firearm had been retrieved. It's debatable as to whether that was when the exigency dissipated. So the evidence of Mr. and Mrs. Rana. So Mr. Rana chose to testify in his defense after it was explained to him that it was his constitutional right to remain silent and have the Crown prove his guilt beyond a reasonable doubt. So this is always a consideration whenever you're dealing with a case like this, because you have to decide whether or not you want to testify. And once you get up on the stand, you're open to cross-examination. There is no, you see in the US where people are up on the stand and they say, I decline to answer that question on the grounds that it may incriminate me. Well, you don't get that here in Canada. Your right is to not get up on the stand. But if you do, fair game. They can go after you with anything that is relevant and not otherwise sort of objectionable. So it can be a very strong protection not to testify, because then you can avoid exposing yourself to that. Mr. Rana might have been able to get this evidence out through the evidence of his wife without ever testifying. And that might have been a better move. But again, it's hard to say after the fact, but this is the sort of thing that a lawyer would have looked at to see whether that was the way to go. And yeah. I also note that they wouldn't have been able to hold him not testifying against him because he's got a charter right to remain silent. So they couldn't say, why isn't Mr. Rana testifying? Shouldn't we be hearing from him as to what happened? Nope, that is an impermissible line of argument. Can't do it. All right, so he further agreed to have his evidence on the charter of voir dire apply to the trial issues to avoid being cross-examined twice. Again, sensible. He's 50 years old and does not have a criminal record. As noted above, he's a highly intelligent man with a degree in biochemistry and business administration. He also completed a couple of years of medical school. Mr. Rana has been married to his spouse, Mrs. Rana, for years. The couple have 3 children. The parties moved from Oshawa to Ottawa several years ago. Mr. Rana explained that while living in Ottawa, he enlisted with the Canadian Armed Forces and was a commissioned officer as a second lieutenant medical in training. He received firearms training in Borden, Ontario, and developed a passion for firearms. In 1990, he purchased a 9mm Beretta semi-automatic handgun as a legacy item to pass on to his children. The firearm was never used, never touched, and had no ammunition. Mr. Rana applied for and was granted a CFRO in respect to this firearm. CFRO is the code that the dispatcher was using. This is a dispatch code. He has a firearms license. He has a PAL. And in particular, he's got what we usually call an RPAL, so a restricted firearms license. This is sloppy language by the court, and I don't approve, but of all the things, this is minor. It just annoys me when we see this kind of thing going on, because it really suggests to me that there is a giant gap in understanding between sort of the courts as they are and the courts as they should be. This should be something that the courts understand as a matter of course, because it comes up a lot. And so, yeah. Anyway, they clearly recognize that he has a license and so forth. There's no evidence before me that his spouse, Mrs. Rana, was also lawfully permitted to possess and store firearms on the date in question. I guess the other question is there any evidence she wasn't? But moving on. Mr. Rana testified that the firearm was stored in a locked safe, which was a metal box advertised to hold valuables. If you've seen some of the previous, cases, like say the Queen and Barnes, and I have a video on that, you should watch it. This seems to be an important classification here. I'll talk about that a little later. Over time, the safe was mainly used to store his wife's jewelry. In cross-examination, Mr. Rana provided further details about this safe. He said he purchased the safe about 25 years ago, possibly from Walmart, and added, "My wife has taken it over for her use, and she has the key to that safe." On the date in question, the safe was stored on the floor of his bedroom closet. When pushed further about its exact location in the walk-in closet, he said it was on the right half side of the wall upon entering the walk-in closet, which is the corner furthest from the door of the bedroom. The implication of this evidence is that somebody standing at the threshold of the bedroom may not be able to see a safe in the closet. Mr. Rana added that his wife had the key to the safe. Crown Counsel, Mr. Black, challenged him on this issue, producing this evidence. Only your wife had access to the safe? Yes. And only your wife had been the one using the safe for a number of years? Yes. I take it there was only one key for the safe that you're aware of? Yes. And you didn't have possession of that key? No. Your wife had possession of the key? Yes. This is a very common pattern for cross-examination, because you want, when you're cross-examining a witness, to keep control of that witness. You want to guide that witness. Ideally, like the perfect cross-examination is that you have essentially laid out a train track that is from where your witness is starting, from the evidence they've given before, to where you want them to be, which is usually something that contradicts or undermines them. And so if you can sort of think of that track between those two locations, the perfect cross-examination is one where you just set them on that track and you can push them along it the whole way, keeping control of what they're going to respond because you can frame your questions well, such that they inevitably reach that destination that you want them to be at without ever having an opportunity to sort of jump the track and go in a direction you weren't expecting. So the perfect cross-examination is one where you maintain, and you're maintaining control in terms of how you ask the questions and your demeanor and the pattern that you sort of develop. But, done well, you want to keep the witness going where you want them to go. You don't want to let the witness kind of go in their own direction, because the witness probably doesn't want to go in the direction you want them to, especially if the witness is the accused and you are the Crown prosecutor. So this pattern of asking these like yes/no questions to get the key bits that you want, that's very common. And this is just skill in advocacy. So good work on the part of the Crown. But this kind of illustrates some of the stuff that happens in a trial, and there's no real larger issue here, but I kind of mention it because it's neat and to share it with you guys. So Mr. Rana testified it was never his intention to use the firearm to threaten Mr. Qureshi. Further, the firearm could not be used as it had no ammunition, and there was no ammunition in the residence. It says there was ammunition in the residence, but in context, he means there's no ammunition in the residence. Looks like the judge missed a word in this judgment. With respect to the 911 calls, Mr. Rana acknowledged in hindsight his choice of language to the 911 operators was careless because he was frustrated the police didn't attend at his residence immediately. Do you think it might have been a better idea to, tone it down? He admitted Mr. Qureshi was at most a trespasser, and he was prepared to mislead the 911 dispatcher in leaving a false impression about the circumstances of the urgency to gain an advantage in having the police attend more quickly. The gain an advantage is clearly language from the Crown, basically putting it to him. You were willing to mislead the 911 dispatcher to gain an advantage. So this is basically the Crown is attacking his credibility, and doing so, we'll see sort of how much that impacts, but this is a good angle on attacking somebody's credibility. You were willing to lie to the 911 dispatcher, so of course you're lying here today. That kind of thing. You are a liar. We have established that. That's not a great place to be when you're sitting in court, is established as a liar. So Mr. Rana said it was the first time he called 911. I note parenthetically, Mr. Rana was never charged with an allegation of public mischief. Maybe they should have. Like, that would have been it would have been another route for the Crown to go. It is arguable whether sufficient grounds existed for this offense based on his careless use of words, which would have the effect of inciting an emergency involving a handgun and possibly threatening to use it in self-defense, which has a specific legal meaning. Mr. Rana added he was clear with the 911 operator he would not use the firearm. In his testimony before the court, but not to the 911 operator, he added, "She has access to it and she would never give it to me." Now, some of his comments, if we remember them, sounded like he would use the gun, although in one of the comments he said he wouldn't. So there's some equivocation here, there's some waffling. What we can see here is the effect of the Crown's attempting to attack his credibility. With respect to control over the firearm, the pertinent evidence was as follows. So during that period of time, that extended period of time, your wife, as far as you were aware, knew that apparently the gun was in the safe. As far as you were aware, your wife knew that the gun was in the safe. This is a really clumsy and awkward question, and, I might or might not have objected to it because it's a compound question. There's two questions here, but they're kind of the same question. So I think that the best you'd get on an objection to this is making him rephrase it, which can be useful if you're a lawyer because you can sometimes break up the other side's sort of pattern of cross-examination when they ask an improper question by objecting. But that's a lot harder to do if it's you on the stand. So, again, a great place to have a lawyer. So, correct. And she had access to it and control over the safe, right? Correct. You didn't have control over the safe, right? I can't have control to open the safe, right? But the safe was there. And in fact, when you wanted the handgun for yourself, you weren't able to get it, were you? When I wanted the handgun, no. Sir, you're the only one in the household to possess a firearm, right? Yes. After establishing that Mr. Rana knew the inherent dangers of firearms, including a 9mm handgun, Mr. Rana acknowledged he knew it was important to prevent handguns from being handled by people who are not trained to handle firearms. He admitted he knew he was clearly responsible for the handgun that was in his home. Again, do you think maybe it might have been better if he wasn't cross-examined on all of this? That's just a tactical, question, but yeah. Mr. Rana explained he went upstairs to his bedroom to call 911. While on the call, he saw his wife go into the closet with the locked safe. Mr. Rana confirmed it had probably been a couple of years since he last saw the firearm and knew it would be in the locked safe. Mr. Rana was challenged on whether he knew his wife had removed the firearm from the closet. He stated, "I asked my wife for the gun. She said no. I asked her again. She was not willing to remove the handgun from the safe. Then I asked her again and she relented, removed the handgun from the safe and removed it from the box. I asked for the handgun. She said no. And then at that time, she had it with her and she left the bedroom and I was upstairs." So she doesn't want to give the gun to the guy because my guess, volatile situation, worse things might have happened if she'd handed this gun to the guy. But if you're a regular watcher, you might have seen my video on why your spouse should have a firearms license. A lot of problems here would have been solved if Mrs. Rana was the holder of an RPAL. So many problems would have been solved. The outcome on this would have been much better, I think. It would have been a much easier case for Mr. Rana. So if you haven't watched that video, watch it. And yeah, this case provides an excellent illustration on why that's a good idea. Because they could, in this case, they very much could have charged Mrs. Rana with possession of a restricted firearm without a license. I don't know if they did, and she was, charged separately, or if they just decided to let her go on that one. But they absolutely could have proceeded with charges against Mrs. Rana. And I think that they would have had a much stronger case against Mrs. Rana here than they have against Mr. Rana. So, although we'll see what happens with Mr. Rana. So Mr. Rana testified he saw his spouse put the firearm under her chador, which is an Urdu word for a traditional shawl worn by a woman to cover her entire body, and walk out of the room. He knew she went downstairs, even though he was distracted and still on the line with 911. He told his spouse, "Make sure you put it back in the safe." After 911 and knowing after calling 911 and knowing his firearm was no longer in the locked safe, he went downstairs and directly went outside and waited on the porch to avoid any conflict with Mr. Qureshi. He did not take possession of the firearm, which was still in the possession of his spouse, because he knew she couldn't have returned it to the safe as she remained in the kitchen with the children. He saw a number of police officers situated 50 feet away. Mr. Rana tendered a number of photographs depicting their position as Exhibit 8. When police are rolling up to your house, you want your guns in the safe, not tucked under somebody's clothing. That could end really badly. For example, if the police officers entered and one of them spots the firearm, that's going to be a real tense situation. So that gun should have gone back in the safe, and so many problems might have been avoided by that. So he waved them down and did so to assuage any concerns that he may be in possession of a firearm. He testified that Constable Pallister asked him about the firearm, and he told him he didn't have it on his person. Mr. Rana acknowledged he wasn't forthcoming about the firearm because the basis of his 911 call was to remove Mr. Qureshi from his home, and he wanted the police to remove him, but they seemed to be fixed on the firearm. While he spoke with other officers as well, nobody searched him for a firearm. Again, exigent circumstances, they say. This is a big deal. Nobody pats him down? Really? Okay. But again, he's upset because the police aren't dealing with Mr. Qureshi, and I think kind of justifiably so, because that's what he was calling the police about. but the police, they want to find this gun. So Constable Pallister was the first to enter his residence, with the other two officers following behind. Both Birmingham and Clausen began to immediately ask him, "Where's the gun?" Because of course they do. That's going to be their primary concern here. He repeated he didn't have one. Mr. Rana testified that the officer said, "You said you had a gun in the 911 call." Clausen went outside and returned and told him he was on a 911 call and said you had a 9mm Beretta and you said you would use it. He testified he felt harangued by the Constable Birmingham about the location of the firearm. When he refused to reveal the location, he testified Constable Birmingham told him he would charge him with public mischief for calling 911 and saying he had a gun, that he was threatening to use it. Again, he was never charged with public mischief. Mr. Rana said that this was uttered to him with his children present, and he felt humiliated as he was a registered firearm owner. Mr. Rana testified he admitted he had a firearm and kept it upstairs. However, he felt pressured to divulge its whereabouts. When asked where, he responded the bedroom. Unlike the police account, he did not say it was in a box. He was worried he would be charged if he didn't respond to the police questions. He went upstairs with Sergeant Clausen into his bedroom. Constable Birmingham remained downstairs and came up afterwards. Clausen stood at the threshold of the closet as Mr. Rana began to look for the firearm in the closet. He could not find the firearm and called for assistance from his spouse, and Mrs. Rana came upstairs with Constable Birmingham. In cross-examination, he was challenged on this evidence, resulting in the following exchange. "If you don't have access to the safe, though, how could you look for it?" "I told my wife to put it back in the safe." "So did you look in the safe when you went up to the closet?" "No." "So you had no idea where the firearm was, right?" "Yes, at that point in time, I did not know where the firearm was." I think that this was actually a fairly canny bit of cross-examination by the Crown. He spotted an issue. You told your wife to put the gun back in the safe. How are you going to look for it if you don't have a key to the safe to dig it out? Maybe there's not actually a safe here. This is where the Crown is going on this one. So Mr. Rana testified his spouse located the firearm in the closet and handed in the gun box, which was heavy. Based on the weight alone, he knew that the gun was in the box. Before giving it to him, he tried to open it and make sure it was inside. Clausen forbade him not to open it. He handed the gun box to Clausen, and his spouse left the bedroom. Clausen opened the box and pulled the firearm out, ejecting the magazine. It had no ammunition. He accompanied Clausen and Birmingham downstairs. He believed Birmingham tried to embarrass him by placing the firearm on the console in plain view of Mr. Qureshi, who was still in the residence. Birmingham told him he would be charged with criminal offenses as the firearm was unsafely stored, the box was not locked, and the firearm did not have a trigger lock. Mr. Qureshi was ultimately told he could leave and left. So they don't even want to pursue Mr. Qureshi here. They just kick him out the door. One wonders why they didn't just remove Mr. Qureshi at the outset. But anyway, moving on here. Mr. Rana's detention and arrest. Mr. Rana testified after the gun box was taken downstairs and displayed for everyone to see. Birmingham told him he would be charged with unsafe storage of a firearm, but he wasn't formally arrested or charged at this point. Instead, the police asked him for his firearm registration certificate, which he produced, and Clausen took both the firearm and the certificate outside and told him to stand by. In my view, any reasonable person standing in the shoes of Mr. Rana at this point, objectively, would feel detained. This arguably amounted to a detention for purposes of the charter because he was told to stand by, which means he was not free to move around or leave the house. Even if the police meant for him to wait, the waiting was in relation to confirming the grounds they had just acquired to suspect a criminal offense, not something else. As I will explain later in these reasons, I am satisfied Mr. Rana was detained at this juncture and not earlier, as he was clearly suspected of committing a criminal offense. Do you think maybe it might have been earlier that he was detained when he was told, listen, if you don't help us find this gun, we're going to charge you with public mischief? That seems to me like it might count as a detention there, where they're telling him, help us or else. The police were asking him questions about his registration certificate related to the reasons for the detention. This triggered a police duty to provide him with his rights to counsel without delay or immediately upon being detained. There was no evidence led as to this occurring. Clausen confirmed Birmingham issued Mr. Rana an appearance notice, which might have been a function of him being arrested in his home, but it doesn't erase the obligation to provide timely rights to counsel. So they should have told him, you have a right to speak to a lawyer and we'll let you do that. But they didn't do that here because reasons, essentially. Mr. Rana testified during his examination in chief. Upon learning he would be charged with an unlawful storage offense, Clausen told him the gun box didn't have a lock. As a result, he testified in a manner which might suggest he made some out-of-court utterances upon being confronted with this allegation, which would otherwise be inadmissible as prior consistent statements. This did not invite an objection from the Crown, and I've carefully reviewed this evidence and have determined that the utterances were not actually uttered to the police officer at the time, but rather constituted his trial testimony as to what was in his mind. Either way, in the Queen and Edgar, the Court of Appeal observed that an admissibility inquiry for this kind of evidence must consider 3 factors. 1. The accused must testify. 2. The statement must be made when the accused was arrested or when first accused of committing a crime. And 3. The statement must be spontaneous. Here, there were no utterances per se, but I will address the evidentiary impact, if any, of his reaction to the charges below. So essentially, he's saying that when he was confronted with this, he had certain thoughts. And so the court is examining whether those thoughts are admissible. And, yeah. Finally, Mr. Rana added, in the interest of full disclosure, he wanted the court to know that the criminal charges resulted in significant collateral damage. Thus, he commenced civil proceedings against the police, and they remain outstanding. Why would you tell the court this? Do not tell the court this. This is not relevant, and all it can do is undermine your evidence. This is the kind of thing that you might bring up to cross-examine somebody. No, bad. He also mentioned his charges in the SCJ, as he is now on the police's radar. In cross-examination, he confirmed the civil proceedings are not in relation to the specific officers in this case, but some of the material from this case is mentioned in the civil proceedings. Again, the charge in SCJ plays no role in my determination of the issues. Why would you bring that up? That is not a thing to put before the court here. And so this is a bad tactical decision by Mr. Rana. So on to the evidence of Khadija Rana, so Mrs. Rana. Mrs. Rana was called by Mr. Rana and testified with the assistance of an Urdu interpreter. She was examined in chief by Mr. Rana and cross-examined by Mr. Black, who explored the possibility of bias in that her husband told her what to say. On several occasions, she denied being coached by her husband. Mrs. Rana confirmed the evidence of her husband in that he is a registered firearm owner who possessed a 9mm handgun, which had been purchased in 1990 and stored in her jewelry safe, which remained locked. The safe was with them in Ottawa and brought to Oshawa when they moved. It was stored in the master bedroom closet, which has a walk-in closet. Mr. Rana had never asked for the firearm, and to her knowledge, the kids didn't even know he had a firearm. So I suspect that they mean that the master bedroom has a walk-in closet rather than the closet has a closet. Stranger things have happened, I guess. On the night in question, Mr. Qureshi, who was a family friend, attended at their house as an unwanted guest. Mr. Rana immediately called 911 to have him removed and asked her for the firearm. She refused. Mr. Rana asked her to open the safe, and she refused again. She refused both requests because she feared the firearm might be used to scare Mr. Qureshi, and she wanted to avoid conflict. Smart! Without telling her husband, she removed the firearm from the locked safe and removed it from the gun case and hid the firearm under a shawl, knowing that the police had been contacted and were on their way. She told Mr. Rana she had the firearm on her and went downstairs. An unloaded firearm is really just a good way to get yourself into a lot of trouble. If there's a situation where you need a firearm, you probably also need the ammunition for it. Anyway, prior to the police attending, Mr. Rana told her to put the gun back into the safe immediately. She was in the living room with her children, focused on Mr. Qureshi, and refused to return it because she didn't want to leave him alone with her children as Mr. Rana was waiting outside. When the police arrived, one police officer entered the residence and searched Mr. Qureshi. The 2 other officers followed Mr. Rana upstairs to the bedroom. She said one officer began to shout, "Where's the gun?" called 911. He became furious, insisting that if Mr. Rana didn't turn over the gun, he would be arrested. Again, you'd think that the first thing they would do would be to pat down the occupants, in which case they would have found the gun. Just kind of a thought here. And she actually probably would have been in a lot of trouble, so she's probably lucky that they didn't. Mrs. Rana said she still had possession of the firearm, but didn't say anything as she became scared. She did not volunteer she had the firearm because nobody asked her, and her children were in earshot. Mr. Rana proceeded to go upstairs with a police officer and yelled down at her, asking, "Where's the gun?" She went into the bedroom and, without anybody seeing, removed the firearm from her shawl and deposited it into the box which was on top of the safe. She handed over the gun box to Mr. Rana. She confirmed Mr. Rana was not in the closet with her. Finally, she saw Mr. Rana holding the gun and attempting to open the gun box, but a police officer said, "No, let me open it." The officer took the firearm and the box from Mr. Rana. In cross-examination, Mrs. Rana was challenged by Mr. Black as to whether she reviewed any material with Mr. Rana in preparation of her testimony. She adamantly said no, explaining she can't read English and only speaks English a bit. Further, she was aware of the court's order not to discuss the evidence and abided by it. She repeated there was no need to discuss the evidence because she was present for the events and saw what happened. Mrs. Rana confirmed she was not a licensed firearm owner at the time of the incident. She was aware that Mr. Rana was a licensed owner and stored the firearm in a safe, which she described as a black box that opens with a key. She said it was stored in the closet, in the middle of the closet, but behind things. She was the only person who had access to it because it only contained her jewelry and the gun. She added that it was stored in the master bedroom, which at the time was being used by Mr. Rana as she was sleeping with her kids in a different room. That said, her items were still in the master bedroom, including her clothes and jewelry. Mrs. Rana was firm in her position that prior to police arriving at her home, Mr. Rana asked her for the gun, and she said no. This resulted in an argument, and she went into the closet, unlocked the safe, and took the gun with her and hid it under her shawl because the police were on their way. She left the gun box on top of the safe and went downstairs into the kitchen to be with her kids as Mr. Qureshi was still in the house and Mr. Rana was outside. She said Mr. Rana knew she had the gun because he was on the phone with the police. She was worried about Mr. Rana having a firearm in his hand when the police arrived. That is a sensible worry. The police might have responded badly to that. Mr. Black asked her, as the keeper of the key to the safe, why didn't she just leave the gun in the safe and hold on to the key? She stated, it all happened very fast. If Mr. Rana, finds the key, he could take the gun out of the safe, and he would be in trouble. She added she was scared and confused and worried about what might happen between her husband and Mr. Qureshi. When pushed on what Mr. Black suggested was an illogical explanation, she added, you might be right, but at that time I kept it with me. People don't necessarily, in tense situations, make good decisions. Sometimes people do dumb things, and this case is a great illustration of that. And part of why people do dumb things is because you don't really mentally rehearse for things. So fire drills are a great example. You have fire drills, in businesses and hopefully also in your home, just so that if a fire happens, what are you going to do? What's the plan? So that you're not trying to figure out how to escape your house while the house is on fire and you're not thinking straight. It's also worth spending some time to think on things like, what do we do if there's an intruder? That might have helped here. Finally, she said that when the police arrived, they kept asking her husband about the gun. She didn't speak up because nobody asked her about the gun. Do you think the police drew some conclusions here that maybe in, the modern age they shouldn't have drawn? It seems like they probably decided that Mr. Rana, for some reason, Mr. Rana might have the gun, and that Mrs. Rana, for some reason, Mrs. Rana couldn't possibly have the gun. Yeah, I'm just going to leave it there. And she began to worry about having the gun on her. Again, sensible. When her husband called for her, she went upstairs into the bedroom and without anybody seeing, removed the gun from her shawl and placed it in the gun box, which was still on top of the safe. She handed the gun box with the gun to Mr. Rana, not a police officer. Findings and analysis. I now turn to my findings of fact and analysis of the legal issues, commencing with Mr. Rana's argument that the information charging him was a nullity, so that I'm not going to worry about here. So previously I've gone through a lot of testimony, and I think it's important to go through the testimony before we get to the findings of facts, so that we can consider, if we agree with the judge. Now, I note that on appeal, you're not usually going to have a whole lot of success disagreeing with the judge's finding of fact. Those you're pretty much stuck with, but they can help us decide what we think of this case. But here's the judge's findings of fact. And so these are the facts as determined at the trial, which determine, these are the facts that we have to apply the law to when we're considering, is this a correct decision, legally speaking? We can have our own opinion as to whether we would come to a different thing, but if you were arguing this on appeal, these facts are the ones you're stuck with, unless you can show that there's sort of blatantly and obviously wrong, it's a really tough test for that. So Mr. Rana, sorry, I'm skipping over all of this bit because this is about the two information thing, which I don't think is a really a big deal here. So issues, section 2, 3, 4, which are sections 8 and 9 of the Charter. So overview, Mr. Rana advances two arguments about section 8 of the Charter. The first complaint involves the police entering and searching his home without a search warrant, leading to the seizure of the firearm. The second involves the failure of the police to file a timely report authorizing lawful detention of the firearm. A corollary of the first section 8 argument is a complaint he was arbitrarily detained in his home in violation of section 9 of the Charter. A third and related complaint to the report issue is a separate complaint under section 7 based on the police filing a new report during the trial, which he says amounts to an abuse of process, which I am not going to deal with here. I will address issues 2, 3, and 4 together as the evidence overlaps. So, legal principles. Section 8 of the Charter guarantees the right of every person to be secure against unreasonable search and seizure. It serves to protect the privacy of individuals from the intrusive conduct of the state. Section 8 is engaged when agents of the state intrude upon a reasonable expectation of privacy. The right to privacy protected by Section 8 of the Charter is connected to the underlying values of dignity, integrity, and autonomy. The Supreme Court has repeatedly held that people have a strong expectation of privacy in their dwellings, which includes the ability to exclude people from and deny entry to their dwelling. And here they cite the case of the Queen and Feeney, which is a big case on when the police can enter your house and, them needing a warrant to do so. So I'll probably cover Feeney in another video. This one's already going to be way long, but that's sort of an important bit of background there or context. It is common ground that the police did not have a search warrant to enter or search Mr. Rana's residence. In the absence of a warrant, it falls on the Crown to justify the search. In order for a warrantless search to be constitutional, the Crown must meet their burden on a balance of probabilities in proving 1. The search was authorized by law, 2. The law must be reasonable, and 3. The search must be conducted in a reasonable manner, and that's the Queen and Collins. If you're a law student, Collins is still good law on the search issues. It is no longer good law on the 24-2 issues. That's an important sort of division. For the 24-2 issues, you want grant. So the parties did not make submissions on the second prong of this test and instead focused on the first and third requirements. I will address them all. So 1, was the warrantless search authorized by law? The Crown defends the warrantless search of Mr. Rana's residence by arguing the police were permitted to make a warrantless entry into his home based on the common law powers which exist when responding to emergency 911 calls. Further, the safety search that followed was an extension of this permitted entry, and there's a whole lot of cases they search. These principles are well settled, but can sometimes be challenging in their application. A recent decision from the Ontario Court of Appeal provides a succinct two-step framework. In the Queen and Stairs provides a two-step framework. Okay, I'm amused. That's it's completely, nothing law, but that just amuses me. The first step involves considering whether the police were operating within the scope of a duty imposed by statute or by the common law. If so, the second step involves considering whether the actions taken in fulfillment of that duty constitute a justifiable use of power. And that's the Godoy case at paragraph 12, Mann at paragraphs 24 and 25. In other words, the question is whether the exercise of power was reasonably necessary in the circumstances. In this case, I agree with the Crown that the police were justified in entering Mr. Rana's residence because they were acting within their common law duties to respond to emergency 911 calls, and there were exigent circumstances in doing so. Now, as far as this goes, I think that the judge is pretty unassailable that they could come into the house, and even that they could look around the house and make sure that there were no people who were sort of in danger. So there's no controversy that 911 calls were placed about an intruder, and information intimated to the dispatcher involved the caller stating he was a registered gun owner who may use his firearm in self-defense as he gets violent. The clear implication of this is that the caller would use the firearm possibly as a lethal weapon. That's important context for the police action in this case. And it is. Even though Mr. Rana clarified his intention of not using the weapon, the police would have been negligent in not treating this as an emergency or with exigency. The question then becomes, how do you deal with that exigency? How do you deal with that emergency? Is there better circumstances or worse sort of methods? So To a large extent, the common law duties of the police rest in sync with their statutory duties. For instance, at common law, the police have a duty to preserve the peace, prevent crime, and protect life and property. It requires that the police keep the peace, prevent crime, assist with crime prevention, apprehend criminals and other offenders, and assist victims of crime. I accept the evidence of the police officers who all testified they were responding to a 911 call, armed with information the caller was ready to use a firearm as a lethal weapon. They were squarely within their common law duties to preserve the peace, prevent crime, and to protect life. If Mr. Rana had just placed a 911 call asking for help to remove a trespasser without reference to possibly using a firearm, I seriously doubt the police would have had any lawful authority to enter his residence. This is the judge saying, Mr. Rana, you kind of screwed yourself on this one. As the cases make it clear, a person has a very high expectation of privacy in their own home. The scope of the police's implied invitation would have ended at the doorway absent them being let in by Mr. Rana if the 911 call was only a trespass call. Of course, he was going to let them in. Like this, obviously, he was going to let them in to remove Mr. Qureshi. Here, they were called by Mr. Rana and invited into the home in response to a true emergency flowing from the 911 call. The first step in the analysis is easily met. The more vexing question is the second step involving the actions taken by the police in response to the 911 call and whether it was a justifiable use of the police power. After entering the Rana residence, the police pursued a search of the firearm within the residence. The Crown defends this action based on two planks, arguing that either would be sufficient. First, the search was justified as an exigent circumstance, and second, it was justified for safety purposes because of the nature of the 911 call. Mr. Rana says there was no longer an exigency once the trespass aspect of the 911 call had been extinguished, and the search was not done for safety purposes. Instead, he says the search was unlawful because 1. He was investigatively detained in his home without reasonable suspicion. 2. There were no grounds to suspect any safety concerns because, as he was a registered firearms owner, of course, that kind of goes away when you start making threatening comments on the 911 tape. 3. There were no reasonable and probable grounds to arrest him for a criminal offense, which would have provided the police a lawful avenue to search him and his immediate surroundings incident to an arrest. So, Mr. Rana further argues that on the third prong of the Collins analysis, well, let's go back to the second step before I go that far. So, the exigent circumstance here, it seems to me that they could have dealt with this by doing a search of the house for people, gathered all the people, and made sure that they kept an eye on the people. In terms of having to go search for the gun, that seems like a different kind of step. Because finding the gun, the gun, again, isn't going to go off without a person. So that's a different thing. That's looking for evidence as opposed to, stopping the exigency, which is better dealt with by dealing with the people, particularly given that they don't actually pat down either of the people, Mr. or Mrs. Rana. How do you... Anyway, that's frustrating. Mr. Rana further argues that on the third prong of the Collins analysis, the Crown has not met their burden of proving the search was conducted reasonably because he never consented to being searched, and any purported consent was secured through coercion because he was threatened with a mischief charge if he didn't participate. The Crown says the manner of search was reasonable because the police were lawfully in the residence. Mr. Rana was not detained until his arrest, and there existed lawful grounds for the search. Further, Mr. Rana simply assisted with the search on his own accord. Mr. Rana's related complaint on the Section 8 issue is that the police arrested him in his home without a warrant, which is contrary to the Supreme Court's decision in Feeney. Feeney doesn't really apply here, I don't think. So the Crown says a Feeney warrant was unnecessary in the circumstances and did not amount to a separate Section 8 charter violation. I think the Crown's right on that. In assessing the second step of the analysis, a number of questions must be resolved, including whether Mr. Rana was detained within the meaning of the charter, and if so, when. Mr. Rana's legal status as a detained party may impact the analysis about the permitted scope of police powers. I turn to this issue next. So Mr. Rana says he was detained in his home when the police entered his residence and began to search for the firearm. If he was right, this would have meant the police were required by law to provide him with his rights to counsel and caution him that anything he said or did could have an incriminating effect. I disagree. Mr. Rana was under investigative detention when he first encountered the police and conclude that his detention crystallized when he was told by Constable Birmingham that he would be charged with a criminal offense of unlawful storage and to stand by, ostensibly so police could investigate the circumstances of his registration. Therefore, while he was detained in his home, it is much later during the police encounter. In the Queen and Grant, the Supreme Court held a psychological detention by the police can arise in two ways. where an individual is legally required to comply with a direction or demand by the police, or where there is no legal requirement but a reasonable person would feel obligated to comply. In assessing when a detention is crystallized, it is important to keep in mind not every interaction between the police and a person will amount to a detention. Rather, a detention requires significant physical or psychological restraint. In the Queen and Lee, the Supreme Court held that even when a person under investigation for criminal activity is questioned, that person is not necessarily detained. A detention must be measured objectively, not purely from a subjective point of view. The question is whether would a reasonable person in the place of Mr. Rana, who placed calls to 911, feel that they had to comply with the police. In Grant, the Supreme Court adopted 3 non-exhaustive factors to consider when determining if a detention has occurred. 1, the circumstances giving rise to the encounter as they would reasonably be perceived by the individual. 2, the nature of the police conduct. And 3, the particular characteristics of the individual were relevant. In my view, the 3 factors militate toward finding that Mr. Rana was detained only when the police determined that they would charge him with a criminal offense. It did not crystallize before. I say this for the following reasons. The judge keeps going here, and I really want to tackle this, but I kind of got to get out everything the judge puts in his reasons, so here I keep going. First, the police attended at Mr. Rana's residence not because they had determined he had committed a criminal offense, but rather to investigate a 911 call where the caller said he would use a lethal weapon in self-defense. Even though this was tempered by subsequent calls, it was the driving force behind the call, with a trespass concern as ancillary to the primary purpose of fending off a gunfight. Mr. Rana, once again, we see he kind of screwed himself up because his purpose for calling the police became the ancillary purpose, not the primary purpose. Whoops. You kind of want the police's primary purpose to be helping you out, not arresting you. The police were trying to prevent a possible crime before it happened. Safety was foremost in their mind. Mr. Rana was not an accused or even a suspect during the initial police contact, although they are threatening him with charges. So, Second, I find that the police politely asked Mr. Rana about the whereabouts of a firearm in a general way because they had no idea if and who was armed. Their actions in searching Mr. Qureshi are evidence of this. Again, why don't they search Mr. Rana? Mr. Rana was not targeted or accused of being in unlawful possession of the firearm. Further, I find that Birmingham probably did say to Mr. Rana he would charge him for mischief if he didn't assist with the investigation of the firearm. However, I don't accept this materially impacted Mr. Rana's decision to offer to search for the firearm because, as the evidence establishes, he didn't believe he was doing anything wrong with respect to its storage. It was Mr. Rana who led the charge, with Clausen behind him, who was not in front of him or directing him to a specific room. Again, no kidding, he wasn't in front of him. When a constable, takes control of you, or when a police officer takes control of you, they will almost always be doing so from behind because they don't want to turn their back to you. So I don't know why they're putting weight on that aspect. It was Mr. Rana who led the charge. Oh, sorry, read that. The other officers stayed downstairs and did not use loud, stern voices, curt commands, or clear orders about required conduct. Lee, while a detention can arise even without this conduct, the evidence establishes Mr. Rana never exhibited conduct to suggest he felt detained, nor is there evidence of him asking the officers to leave his residence. Now I'm going to interject here with some analysis because they just mentioned that a detention must be measured objectively, not purely from a subjective point of view. Would a reasonable person in the place of Mr. Rana feel that they had to comply with the police? And he finds that Constable Birmingham probably did say to Mr. Rana he would charge him for mischief if he didn't assist with the investigation of the firearm. Would a reasonable person, being told that if they didn't help with the investigation of a firearm, that they were going to be charged with a criminal offense, feel that they had to comply and assist with that investigation? I kind of think in law, the answer here has to be yes. And this is a legal issue. I feel like this here is our first real ground of appeal, that the detention has to have appeared at this point, and that, in law, it seems that he's detained at this point when he finds that he probably did say that he would charge him for mischief, because a reasonable person at this point doesn't feel that they can walk away. If an officer says, you have to help me with this investigation or I'm going to charge you with something, who would think that they could just walk away from the officer at that point, or even keep silent at that point? I don't see how you could get to that conclusion here. That's very odd. And he says, well, he would have helped anyway. Well, that's kind of predicting an alternate, an alternate timeline. Do we know that he would have done so anyway? How can we say that? The courts have not typically liked that kind of argument in the past. So I think that there's a ground of appeal right there in that. All right, so moving on. Third, Mr. Rana is an intelligent man cognizant of his rights. The police did not take advantage of a vulnerable man. Remember all the things I was saying about how they were talking up Mr. Rana's intelligence and how smart he is and how good he is at, boom. This is where it's coming back to hit him. They're basically saying that the police had less obligation to do this because he's a smart guy who knew his rights. Here's the problem here. I don't know how you get to him at trial. He's a smart guy and he knows these issues at trial, that he was a smart guy who knew his issues at the time. Because at the trial, clearly Mr. Rana did a lot of prep work. He did a lot of homework. He worked hard on this. It's evident from this case that he did a ton of research and work and so forth to go into making all of these arguments. So yeah, he'd have been an intelligent man cognizant of his rights on trial day, but that doesn't necessarily tell me that he would have been at the time. The judge here is using the present tense. He is an intelligent man cognizant of his rights. I don't know if he's in a position to make a finding that he was an intelligent man cognizant of his rights at the time, or that he's actually made that finding here. But yeah, when I said that they would find a way for, Mr. Rana's able representation of himself to come back and bite him, it's all teeth here. He's being bitten. This is where it's biting him right in the butt. So again, if his lawyer was an intelligent man cognizant of his rights, the court couldn't have used this against him. And so this is again a danger of self-representation. On his own admission, he used careless language on a 911 call, which fueled a chaotic scene when he said he would use a lethal weapon in self-defense. He was quick to prove to the police he was not breaking the law and enlisted the help of his spouse in this regard. Again, because he's been told he's going to get charged if he doesn't, do anything. I do not accept Mr. Rana was under investigative detention when the police first saw the unlocked gun box, because there were still no objective grounds to dispel the information of him being a registered gun owner. The detention, in my view, only crystallized moments later after the police inspected the gun box and Birmingham communicated to him he would be charged with an offense and to stand by so they could investigate the circumstances of the registration. In my view, the judge seems to be making a mistake here. He's saying, you're not under investigative detention for the storage issue, but we also have to look at the public mischief issue. And in my view, they do put him under a detention for the public mischief issue. And the evidence that they're seeking to get here, is there actually a gun, is direct evidence on the public mischief issue. So I think that this decision is vulnerable on appeal on this point. So at this point, Mr. Rana's status changed from a member of the public to a suspected party. Suspected parties are still members of the public. But anyway, while this issue wasn't fully argued by the parties, where there are objective facts that give rise to a detention, the onus shifts to the Crown to prove that the detention wasn't arbitrary. It does not matter that Mr. Rana was detained in his own home because a detention can arise in one's home. Prior to the police command to stand by, Mr. Rana was able to move freely in his home and ask his wife for help in searching for the gun. But if he left his house, I can guarantee you he would have been charged with that public mischief. That's what the police told him. So again, kind of seems like there was some detention. I mean, maybe they would let him move around from place to place in the course of helping them find the gun, but that doesn't mean that he could have left or that he could have refused to answer questions. That's the point where he needed the assistance of legal counsel, is at that point where the police started to make those threats, because a lawyer at that point could have said, hey, listen, maybe you just want to shut up right now. Now is a great, yeah, sure, they'll probably charge you with the public mischief, but you know what'll make it easier for them to convict you on the public mischief? If your mouth is moving. So shut up. I mean, if he phoned me at that point and said, hey, the police are threatening me, here's where the gun is, here's what's going on, I would have been, shut up, stop talking, not another word, nothing. and just let the police do what they do. And I think that would have gone a lot better for him for a number of reasons. Going to continue on here. All right. So it is arguable whether he could have left his house after the police took his registration certificate. I don't think it's arguable that he could have left his house after they made the threat, but anyway, moving on. Accordingly, I find Mr. Rana was detained when he was told to stand by, and him waiting for the police to confirm their suspicion without any charter rights was arbitrary. However, this period was very brief and did not also include Mr. Rana's complaint of being arbitrarily detained from the inception. No evidence was acquired during this period of detention. Mr. Rana didn't say anything, nor was he asked questions about the firearm. There was, at most, a notional violation of Section 9 and 10b. As I noted, I disagree strongly as to when the detention kicks in, and in my view, the evidence that they should have excluded here includes his assistance to find the firearm, which then kind of gets you to they also probably would have needed to exclude the firearm itself. So was the search justified by exigent circumstances? The Crown says that in addition to the common law powers in response to a 911 call, the police were authorized to enter the Rana residence because of exigent circumstances. Enter, yes, I agree with that. The question about the search is going to be another issue. Mr. Rana says there was no exigency. And the Criminal Code section, as a response to the Supreme Court judgment in the Queen and Silvera, where they found that the police had violated the appellant's Section 8 rights by entering his apartment to clear it and freeze it while waiting for a pending search warrant. It provides that an officer can search a residence without a warrant if the conditions for the warrant exist, but by reason of exigent circumstances, it would be impracticable to obtain a warrant. While it doesn't define exigent circumstances, useful guidance can be gleaned from 529.3, which sets out two situations that amount to exigent circumstances. First, where an officer has reasonable grounds to suspect that entry into a residence is necessary to prevent imminent bodily harm or death to a person. And second, where the officer has reasonable grounds to believe that evidence relating to an indictable offense is present in the residence, and that entry into the residence is necessary to prevent the imminent loss or destruction of the evidence. Here I am satisfied that there was a bona fide exigent circumstance which permitted the police to enter the residence to prevent imminent bodily harm or death to a person. Clausen testified that there remained exigent circumstances after entry because, as he put it, he didn't know who had access to the firearm. Again, if that's the concern, the first thing I'd want to do is search Mr. and Mrs. Rana and make sure they don't have a gun, say, tucked into their chador that they could, maybe whip out and fire at you if it were loaded. So when they're saying that there's exigent circumstances, they really go about dealing with those exigent circumstances in kind of a weird way, don't they? So this is measured against the 911 call where the caller said he gets violent and may use it in self-defense, which can reasonably mean discharging it, possibly causing death or imminent bodily harm. There was no way for the police to know for sure it could not cause death or bodily harm because there was no ammunition in the firearm. While Mr. Rana said he wouldn't use it, the police were entitled to assume the worst and hope for the best. Their belief of exigency was perfectly reasonable. Just because they were satisfied that the trespasser didn't have a firearm didn't mean the urgency had vanished. It didn't because of what Mr. Rana told the 911 operator. Had he not uttered those words, there may not have been an urgency. This is not a case where the police action caused the exigent circumstances, which are later used to justify resorting to the doctrine, and a case I'm not even going to try to pronounce. The police did not set out to create exigent circumstances. They responded to an alarming 911 call with multiple scout cars. The situation was urgent. In my view, the police were justified in entering the residence because of exigent circumstances. So in terms of entering, I absolutely agree. They had to come in, and I also think it would have been reasonable for them to look around and make sure there's no people hiding or people injured or anything along those lines. But searching for a person is a fairly cursory search because a person is kind of a big thing. You can't stick a person in a drawer. You can't stick a person in your pocket. You certainly can't usually hide another person under your chador. It's not going to be under a carpet. It's not going to be in a vent. It's not going to be in a ceiling tile. A person is going to, they might be hiding in a closet or under a bed, but it's sort of limited as to what you're going to be searching. It's a much less invasive search when you're looking for people than if you're looking for something much smaller. So, was the search also justified pursuant to the common law? Mr. Black also justified the police decision to conduct a safety search within the residence as an adjunct to their common law powers to respond to an emergency 911 call. Mr. Rana argues that after the police attended to the 911 call after entering his home, the principles in Godoy limit the police to the origin of the 911 call, and once that had dissipated, they were no longer authorized to remain in his home and search based on safety reasons. I disagree. However, usually a safety search is going to be, again, a search for people, not a search for objects. So the object search seems to be a different thing, and I've got some concerns here. So the Supreme Court has recognized that police officers who are responding to 911 calls may conduct warrantless searches of premises for safety purposes. The evidence must reveal a reasonable basis for this belief. McDonald was a case that discussed the scope of safety searches in the context of a person who is investigatively detained. In this case, Mr. Rana was not under investigative detention when the police entered, thus his full panoply of charter rights were not triggered. Again, I think this is definitely something that could be overturned on appeal. The detention arose later. Whether or not an unauthorized search is justifiable in the exercise of the duty to protect the public is generally fact-driven and depends on the circumstances of the individual case. The standard is objective, and the evidence must reveal a reasonable basis for a police officer's subjective belief that public safety concerns necessitated a search. So again, we know this guy's a licensed gun owner. Once we solve the issue of the conflict, you isolate all the people, and you determine, are you going to charge Mr. Qureshi with nothing? No, okay, you leave. At that point, the conflict is over. Like, there's no safety concern at that point. There's maybe an evidentiary concern. Unless they were going to rely on the statutory firearm search provisions, but they've already said that's not what they're doing. They're not trying to seize the firearm from him because they consider him to be a public safety risk. So if they were doing that, we'd be looking at a different case, but that's not what they're doing. So in this case, I am satisfied that the police honestly believed when entering the Rana residence that subjective grounds existed which were supported by objective facts that necessitated a search for safety reasons. The police were consistent in their account that they entered the residence because Mr. Rana called 911. As Birmingham responded to Mr. Rana, I didn't go into your house under the Firearms Act. I went into your house because you called 911. This is a rookie mistake Mr. Rana made in the sense that he was believing that this was a Firearms Act inspection. It's not a Firearms Act inspection. Nothing here says Firearms Act inspection. This was not the angle to pursue. So, yeah. In summary, there were ample grounds which included the confluence of the following factors. Mr. Rana's frantic and repeated 911 calls, suggesting that he may use a firearm as a lethal weapon in self-defense. Information that he was a firearm owner, suggesting it was not a fictitious threat. Information that he gets violent, thus a motive to use the firearm. And 4, presence of a third party in the home when they arrived, suggesting the 911 calls actually bore fruit. In other words, they had an objective basis to believe that not only would Mr. Qureshi's safety be in peril if they didn't investigate the firearm, but things could have gotten worse after they left the residence. Wouldn't you just remove Mr. Qureshi from the residence? And if they're worried that they, that they need to seize this firearm for safety reasons, there are statutory provisions that they should have followed, and they didn't. So I think that's a problem here. The court doesn't consider the 117 issues on this one, Section 117 of the Criminal Code, and they really ought to have. So they say it would have amounted to police negligence if they simply left Mr. Rana with a handgun in his residence when he told the police he was ready to use it. His vacillating position on the 911 calls wasn't enough to negate any objective facts that suggested he would use the handgun in self-defense. Overall, the police reference to safety concerns was more about the exigency of exploring the firearm threat. Either way, the police had ample authority in law to search based on the unique information known to them. So, is the law reasonable? The next prong of the Collins analysis is whether the Crown has proven the law itself is reasonable. There wasn't any argument on this prong, but in my view, this has also been proven. The legal principles permitting police entry into a home and conducting reasonable searches because of exigent circumstances are well settled. And so this provides the police with ample notice on the limits of their powers. Real brief consideration of that one, but moving on. Was the search conducted reasonably? The final prong of the Collins test is whether the Crown has proven the police conducted the search reasonably. The Crown argues the police conduct, when viewed as a whole, was reasonable. Mr. Rana complains it was unreasonable because he was coerced into searching for the firearm. Again, do you feel like that's coercion? I kind of think that there's some problems here with, once he's told that he's got to help out. In my view, this complaint is misplaced because it conflates the manner of search with the lawfulness of the search. The Crown did not defend the lawfulness of the search by arguing Mr. Rana gave consent. Rather, it was defended based on exigent circumstances because the police reasonably believed there was a firearm in the home that could cause imminent bodily harm or injury given his 911 calls. In other words, even if Mr. Rana communicated no consent, the police still had lawful grounds to search the residence. They did not need his consent. I will therefore examine the consent issue under this lens as well, including Mr. Rana's next argument about whether the arrest that followed was unlawful because it was warrantless. First, when the police first arrived at Mr. Rana's residence, they did not know he had a firearm on him because even Mr. Rana said his purpose in waving them down was to assuage any concerns he was armed. This belief continued when they did a quick pat-down of Mr. Qureshi. But again, they don't pat down Mr. Rana, who they're saying the concern is. Why, how do you get... that failure, just to my mind, is a serious thing that the court never looks at. And unfortunately, that's sort of a facts issue that one isn't on the table at appeal. So anyway, I accept Mr. Rana's evidence that she was hiding the firearm in her shawl, but of course this means the police could not have known she had a firearm without having to go upstairs when Mr. Rana decided to search for the firearm. Or they could have patted her down, which would have been reasonable under the whole exigent circumstances. If you're saying, hey, we're concerned that these people have a gun, surely you'd look at the people. But anyway. Second, I find it was Mr. Rana who told the police the firearm was upstairs when the police asked him in a general way, where's the firearm? Again, he was not detained during this interaction, and there was no legal compulsion. Again, I'm not sure that conclusion holds up in law. The question was in response to the frantic 911 calls, indicating it would be used in self-defense. Third, I accept as well that Birmingham probably told him he would be charged with mischief for threatening to use a gun when he didn't have one if he didn't divulge its whereabouts. While this wasn't the most gentle way of dealing with this issue, the police already had grounds to search for the firearm based on the calls. If Mr. Rana was unprepared to assist, it simply would have meant the police had the grounds to search for the firearm knowing it was in the house, which would have required a police officer staying in his home to prevent him from using his firearm to cause the very mischief they were there to avoid, given his calls. This would have done more damage to his expectation of privacy in his home. In this way, while Constable Birmingham's choice of words wasn't ideal, it didn't have the coercive effect that Mr. Rana complains of, given the unique circumstances as they unfolded. So, let's consider a bit of a counterfactual here. And, the court touches on it, but doesn't really dive into it. Let's say Mr. Rana, when he's told, where's the gun, says, hey, I talked to my lawyer. My lawyer says that I should shut my mouth and that this part of my body is not going to help me here. Nothing that, no noises that I make are going to assist me. And so I'm going to sit down, I'm going to shut my gob, and I'm just going to watch what you guys do. The police at that point, when we're talking about the search that they would have done here, let's think about the things that would have been required to search for a gun. You've got to go through every drawer. You've got to go through, vents. You've got to go through, look behind curtains. You got to look, behind books on bookshelves. You've got to, this is a major, major search. And I kind of feel like the court would have been more inclined to find that this search was improper and unnecessary, to search for this gun based on what's the concern with this gun? If the concern is that Mr. Rana is a danger, well, then in theory, you can arrest Mr. Rana to, but it seems to me that the concern here is really solved once Mr. Qureshi is gone. Mr. Rana doesn't say, I'm going to, hunt him down and kill him. He says, I might have to defend myself. This, to me, seems like a situation where you really should get a warrant. Because if Mr. Rana doesn't help, this search is going to be tipping over everything. And, it would have actually been to Mr. Rana's benefit, I think, in this case, if he had just sat down. He'd probably have been charged with the public mischief. I think that ultimately they would have had a hard time proving the public mischief. And that would have been it. But they might have gotten a warrant and they might have turned over his house, in which case, I still think that he didn't be in a better situation in terms of the charter arguments here. So, but the court is really kind of dismissing this issue, and I think that it's actually a bigger issue, because what they're saying here is, under this kind of circumstance, the cops can turn over your entire house without a warrant. I think that's too far on the exigent circumstances doctrine here. I think that this is extending exigent circumstances beyond where it should go. And so this, I think, is another place where an appellate court might say, no, we disagree with that. So carrying on. In this way, I'm satisfied that Mr. Rana's warrantless arrest was lawful and did not require a Feeney warrant. Feeney decided it is necessary to obtain judicial authorization to effect an arrest inside of a residence, resulting in the enactment of a statutory scheme to accommodate these entries. I disagree that a Feeney warrant was required in the unique circumstance of this case. I agree with the observation of Fairburn and Stairs when she made the same point that I've made regarding impracticality. In any event, as important as a Feeney warrant is for protecting the privacy of those inside private dwellings when the police come to effect arrests, they authorize the police to enter a dwelling house described in the warrant for the purpose of arresting or apprehending a person. The whole purpose of the Feeney warrant is to protect the elevated privacy interests in a home, requiring certain grounds to be met before entry can be made to effect an arrest. Yet in this case, the police had already legitimately entered a dwelling place under the ancillary powers doctrine. They were lawfully inside of the residence. It would make no sense to require them to leave to obtain an authorization to enter again, only to effect an arrest that they could clearly make without warrant if it was anywhere other than a private dwelling. This makes sense. You know, this is not a Feeney warrant situation. A Feeney warrant situation is if the police, they think you've committed a crime, they come to your house and they want to enter, they need a warrant that authorizes them to enter your dwelling house for that purpose. They can't just, decide that they want to come in. There are some other exceptions to that, but this is not a Feeney, video, so carrying on. Fourth, despite Birmingham's choice of words, I find Mr. Rana was anxious to find the firearm himself without real police influence. The police did not enter his walk-in closet, even though Clausen was told the firearm was in the closet. It would have been unsafe to simply allow Mr. Rana to retrieve a lethal firearm on his own while the police waited downstairs with his trespasser. And yet they let him retrieve it from the closet, they think. And I think it was safer for Mr. Rana to search in the closet with the police maintaining a safety position as opposed to rifling through a closet while Mr. Rana looked on. Further, it was Mr. Rana who called his spouse for help in finding the firearm. The police never made any demands, questions, or other coercive measures to encourage him to solicit the help of others. I mean, these are findings of fact, but, this conclusion that he was anxious to find the firearm himself without the threat, how do you determine that? You're basically saying that it would have happened anyway without the threat. Well, the threat happened, and so it makes it impossible to predict alternate futures. The court shouldn't put too much weight on that kind of guessing as to what would have happened if you hadn't, It's like saying that this guy was so eager to confess that he would have told us everything even if we didn't beat him with the rubber hose. Well, you did, so no. Also, this notion that it's safer for him to search in the closet. I mean, he could easily, if he'd found the firearm, take the firearm, tuck it into his coat, and now he's got a gun. Maybe he walks out and says it's not in there. And, now he's got a gun and the cop doesn't know it. Or, this is a very weird circumstance if they're saying that Mr. Rana is such a danger. It seems to me that this is much more consistent with a search because they are looking for evidence or they're looking, to seize the firearm or the like. All of these are, evidentiary questions, but I really wish that I could have seen how this trial took place. I kind of feel like the cross-examination on this maybe could have gone a little better. Again, that's just my sort of guessing. Fifth, Mr. Rana acted largely on his own volition because, as the facts reveal, in his mind, he didn't believe he was committing any criminal offenses because his firearm was safely stored. In this way, he wasn't really compelled to incriminate himself. I don't understand this. Even if you think you are innocent, a statement that you are compelled to provide is still a compelled to incriminate yourself statement. So, if I'm a police officer and I bring a guy into the station and I point a gun at his head and I say, talk, and he says, okay, he's first saying, I don't want to talk to you, but then I pull a gun and point it at his head and say, talk. He says, okay, I'll tell you my story. I didn't do anything. And then he tells you his story and he thinks he's actually innocent, but it turns out he's guilty. Sometimes people think they're innocent of things because they don't really understand the elements of the offense. That would still be compelled to incriminate himself, even though you think you're innocent. So I don't understand this. This seems, maybe I'm not getting what the judge is saying, but it seems just wrong. So 6th, the police limited their actions to searching for a firearm and not something else. They didn't start rummaging around in the home looking for other things. They didn't ransack the home. But again, if not for Mr. Rana helping them, they would have ransacked the home. So in Kelsey, the Court of Appeal upheld the constitutionality of a forced entry where the police believed armed male assailants might have taken a hostage, but the court held that the power to enter did not extend to a right to search the female occupant's backpack. Likewise, in Ahmed Kadir, the BC Court of Appeal considered a case where a police officer responded to a 911 call for domestic disturbance and conducted a sweep of the apartment, but also looked inside a shopping bag and a closet in the bedroom and found a handgun. The court held that the officer was not entitled to look in every closet and every room in order to protect officer safety. None of this occurred in this case. The police stayed within their lawful boundaries of the search, which involved the firearm. But again, considering the alternate hypothetical of Mr. Rana doesn't help, they would have had to search everything, like every closet, every drawer, everything. So the only reason they don't have to look in everything is because they compel him to help out. So I've got problems with this reasoning here. So for the above reasons, I'm satisfied the Crown has proven on a balance of probabilities that the search was reasonably conducted. As such, all 3 prongs of the Collins test have been proven, and the warrantless search and seizure of the firearm was reasonable. Turning next to Mr. Rana's argument whether the police had lawful grounds for an arrest. So did the police have reasonable grounds for an arrest? And they cite to Story here. If there's both a subjective and objective component, or there is a both subjective and objective component to the test for a warrantless arrest on an indictable offense, the subjective component requires that the police hold an honest belief that the person committed the offense. In my view, there can be no controversy that Clausen honestly believed he had reasonable grounds to arrest Mr. Rana for careless storage of the firearm because it was given to him in a gun box and was unlocked. The objective component requires that the belief was objectively reasonable in the circumstances known to the officer at the time of the arrest. At the time of the arrest, he was never aware of Mr. Rana's position at trial that it was stored in a locked safe, nor was it incumbent on him as a matter of law to test this belief when he saw the circumstances of the search unfold before his very eyes. The most a firearm registration certificate would do is provide further information about whether he was in fact a registered owner, but the grounds were still present for an arrest. An officer doesn't need grounds beyond a reasonable doubt to effect an arrest. There were ample grounds for a warrantless arrest. This argument also fails. I agree with the court here, 100%. At the point where they arrest him for the storage issue, they have reasonable grounds to believe, and so this seems to me to be a suitable arrest. For the above reasons, I find that there was no Section 8 charter violation on the basis of the police entering Mr. Rana's home and doing a safety search. There was no violation, and a notional violation of Section 9 and 10b. So notional is they're saying there was a violation, but it wasn't a big deal. Report to justice issue. And I have a bunch of things on this. I'm just going to skip it because I see that I'm probably over 2 hours at this stage. The Crown concedes the breach. And basically the court says, yeah, there's a breach and it's trivial and we don't care. This is the kind of breach that you argue because you say that it makes the other breach worse. You know, the main breach in terms of the search. But it's not going to get you to excluding of the evidence in and of itself. So that's all I need to say about that, and we'll cut this down. Now, they're going to do the 24-2 analysis on the minimal breaches that they found, because they didn't find all of the serious breaches. I'm going to go over that real quickly here. So this is the grant analysis, and so they're looking at, a few things. The first is seriousness of the state conduct, which must be placed along a spectrum from minor inadvertent violations to willful or reckless disregard of an accused charter rights. Can you tell I've been at this for a while? All right. In my view, the failure to file a timely report was, as the Crown says, a technical error motivated by good faith. Do you think he's going to exclude on that? No. So, impact on charter-protected rights. I accept Mr. Rana had a high expectation of privacy in his residence and a similar interest in his firearm, but this has to be measured against the circumstances of the lawful entry and reasonable search, which was promulgated by his frantic calls to 911. Again, they're not going to weigh this too strongly. So, yeah, they said More importantly, no evidence was collected, and there's nothing to suggest Mr. Rana needed the lifeline of counsel during this very brief detention. These factors weigh in favor of inclusion of the evidence. But again, if you consider the detention to have happened at the point where the officer makes the threat of, help us or we'll arrest you, then he definitely needed the lifeline of counsel during that detention. So that kind of blows up this whole analysis if we find that the detention happened a little sooner. Adjudication on the merits. So this is, what is society's interest in having this case decided? And the court in Grant basically says you have to be cautious here, because just because the case is serious doesn't necessarily mean that society has a sort of incontrovertible interest in adjudication on the merits, because where the case is serious, the police are also expected to do the job right and to be very careful. But here they say the evidence seized is real and reliable evidence. As noted above, the untimely report and the 2 notional violations were technical errors which did not seriously undermine Mr. Rana's charter-protected interests. So in conclusion, they do not exclude any evidence, and so it's got to go on to the merits of the case. All right, so that's a lot in terms of the charter argument here, but you see ultimately Mr. Rana's charter arguments are unsuccessful, notwithstanding that I think that they actually had merit. So again, there's some real appealable issues in my view in the charter issues, which could be heard by, an appellate court, and they might decide to revoke that or to flip that. I don't know if Mr. Rana appealed or not. If he did, I really hope he's getting a lawyer for the appeal. That's sort of all I can say on that one for the moment. So thank you for watching to this point. I'm going to cut it off here because this is at about 2 hours. And so I'm going to leave the remaining issues to a follow-up video, which will come up sort of the day after this one goes live. And those issues are going to be, now that we've seen that the evidence is going in, so, nothing has been excluded in terms of the evidence, the question of whether he's actually committed the offenses that are charged. And to my mind, there's some really interesting issues on those, as well as some issues, some places where I think the court got it wrong. And so I'll discuss all of that in the, sort of video to follow here. As noted before, I'm going to see if this is available on Canly, the free database. I retrieved this off a paid database, so I'm not sure if sort of everyone will have access, but if I can find it on Canly, I'll link it in the description. I also want to thank my Patreon supporters at the $50 level: Demo, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Toronto Airsoft. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt, as well as those at the $10 level who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.